On September 17th, 1787, 223 years ago, the framers of our Constitution, led by James Madison, ratified the Constitution at the Constitutional Convention in Philadelphia. The Constitution has undergone several changes since 1787, with the addition of 27 amendments since 1789. The courts have interpreted and reinterpreted many parts of our Constitution. The Fourth Amendment and the right to privacy since Griswold versus Connecticut in 1964 has often provided a great deal of public debate. The Fourth Amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Today's speaker for Constitution Day, Scott Shellenberger, is on a daily basis dealing with Fourth Amendment issues as Baltimore County State's Attorney. He will discuss the Fourth Amendment and its effects on new technologies such as cell phones, text messaging, etc. Mr. Shellenberger began his legal career in Baltimore County State's Attorney's Office, working as a law clerk while attending law school at the University of Baltimore Law School. After being admitted to the Maryland State Bar in 1985, Mr. Shellenberger began working as a prosecutor, where he quickly gained the reputation as an advocate for victims of crime, moving through the ranks of the State's Attorney's Office. He has also served as the supervisor of felony screening, career criminal and automobile manslaughter units, and chief of the Child Abuse Sexual Assault Division. Scott Shellenberger was elected State's Attorney for Baltimore County in 2006. He was instrumental in the passage of expanded DNA law, which will give law enforcement agencies the opportunity to prevent violent crime, and has traveled across the state training new law enforcement agencies on the implementation of the law. He was appointed by Governor Martin O'Malley to the Maryland Commission on Capital Punishment, where he has consistently advocated the retention of the death penalty as a tool in the fight against violent crime. As we have seen recently on the news, the role of the state's attorney is critical in the community as an advocate and as a prosecutor. Now it is my pleasure to welcome Baltimore County State's Attorney Scott Shellenberger.
Hello, and I thank you all for being here today. Just going to talk briefly about my office, and then we're going to go right into our interesting topic that is kind of near and dear to all our hearts. Because at one point or another, sometime in your lifetime, either as the victim of a crime, a witness of a crime, or I hope not, as a defendant in some kind of criminal case, all these issues are going to touch upon you. So the first question is, what do we do in the Baltimore County State's Attorney's Office? And the answer to that is, we prosecute every criminal case that occurs here in Baltimore County. That means everything from a simple assault to a driving under the influence, all the way up to rape, robbery, and murder. And in order to do that, last year we handled about 35,000 criminal cases in Baltimore County. And the interesting thing is, some of the topics that we're going to talk about today, Fourth Amendment, Fifth Amendment, Sixth Amendment, any one of those cases can have these constitutional elements in it. You know, if you're driving down the road and you get pulled over by a police officer who suspects you've been driving under the influence, that implicates the Fourth Amendment of our Constitution, and that police officer has to live by that document and abide by the rules that have been around for the last 200-plus years. Most of our cases happen in district court. There's courts in Essex, Catonsville, and Towson, and those are your misdemeanors. Of course, we have a lot of cases in juvenile court and then a lot in circuit court. In order to do all those cases, I have 59 attorneys who work for me, plus myself. And if you consider the fact that I typically handle one case per year, you divide 59 by 35,000, and you can see that my folks handle an awful lot of cases. If you go over to Essex District Court on any given day, there will be an attorney there who's probably out of law school for 2 years, who's handling 50 or 60 cases on any given day. So the numbers are quite remarkable. Why do we celebrate today? And today, as we've learned from John, is September 17th. It's the anniversary of the delegates at the convention ratifying the Constitution. It still needed to be ratified by the people, and that is, each of the states had to ratify the Constitution. And what happened is, when it went out to the people, you know, they had just finished with dealing with England and having really an oppressive government that they had been, revolting against. And when people started looking at the Constitution, I would encourage all of you to get a copy. I have mine here in my pocket. You look at the first part of the Constitution, and the people were saying, where are the protectors? Where's the protection of our liberty? What's going to keep another oppressive government from coming down upon us? And what happened was people saw that, in the original part of the Constitution, there was a tremendous amount of big government and very little personal protection. And so what happened then was in 1789, the first 10 amendments to the Constitution were proposed. And what those amendments did were they were called the Bill of Rights, and they were the place where the citizens gained protection from the government. And these Bill of Rights were ratified by the states in 1791. At the basis of the Bill of Rights is really the colonists' prior experience with an oppressive government and the strong English rule. So, for instance, one of the amendments that is almost never talked about in this country, you could go and do a case law search. You may never find any cases dealing with the Third Amendment concerning quartering of soldiers. But nonetheless, back in 1789, 1791, an issue of can a soldier be forced into your house and live there was an important issue for people who had just finished fighting, the Revolutionary War. It's a concept now that all of us see as so strange and foreign, we can't even imagine that it would happen, but yet back then it was an incredibly important issue. Other concepts that we live by today and take for granted every day as we walk up and down the street or drive our cars. What is it when you're driving down the road that prevents a police officer from just pulling you over for no particular reason? I mean, why is that? Why can you, at any given time, walk into a courtroom and watch what happens? Right now I have a trial going on involving a murder at the Hess gas station in Parkville. Any of you could go to Towson today and walk into that courtroom and watch that trial. What stops the police from beating a confession out of you when they arrest you for a crime? And why is it that when you go to trial, you have a lawyer, and if you can't afford a lawyer, one is provided for us? Well, what does all those things, all of these protections that you know about, that you live by every day, come about as a result of the Bill of Rights? The question becomes, is the Constitution and the Bill of Rights, is it a living document? That is, the words, do they change over time? This little device, a cell phone, has revolutionized crime fighting. Right now, as I'm standing here, if you went to my cell phone provider, they could tell you within about 100 yards of where I am standing. It has completely revolutionized the way we fight crime. 15, 20 years ago, when I used to go to court, I would go down with pictures of, mug shots, and people would say, that's him. Now my prosecutors every day go to court. They're carrying maps with little dots on it to show where a defendant was and what cell phone towers his cell phone was. We call it pinging. You send out a message and it pings off a cell phone tower. My prosecutors go to court all the time to prove that a defendant was in the area of the scene of a crime. When defendants are arrested and we know they committed a crime with somebody else, guess who we get his co-defendants from and find out who he was with? From a cell phone now. Either from the address history or from whoever he was talking to. So the question is the Constitution and the Bill of Rights a living document? Does it change because of technology? Or is it a document that has to be strictly construed and somehow we have to apply those old words to our modern technology? And that's something that our prosecutors and our courts struggle with every day. We just heard a recitation of the Fourth Amendment. And a Fourth Amendment is probably the greatest protection you all have every day in your daily life. It's what stops a police officer from pulling you over for no reason, because you can only be pulled over if there is probable cause. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated. It can't be any clearer than that at how clear and strong that protection is. In 1791, when the Fourth Amendment was ratified, it was very easy to know what those words meant. Those words meant exactly what they said. They couldn't come into your house unless they had probable cause or a warrant. It was very easy to apply the Fourth Amendment back then. But what do you do in the 1900s when a car is invented and cars are mass-produced and suddenly you have people traveling all over the United States in these vehicles and police want to pull them over? How do you take those words about being secure in your houses and person and effects and translate that to a vehicle? How do you do that? And what has become even more complicated is, what does that mean today with regard to cell phones? Cell phones are an incredibly important crime-fighting tool that we use every day. What does it mean to be secure in your person, places, and effects when we start talking about things like cell phones and stop talking about things like houses? The questions become, is your cell phone history private? That is, who you called, is that private? Well, you may automatically think that it is, but think about this. Most of you are probably too young and you probably haven't picked up a landline in your entire life. But when you pick up a landline and you dial a number, nobody knows who you called, because the billing for a landline is just a flat charge, and they don't care how many people you call, how many times you call them. The telephone companies don't track that, and they never have. They track long distance only for billing purposes. So why is that so important with cell phones? Well, every time you make a cell phone call, that's how the carrier decides how much you're going to be charged, how many calls you make, and how long the calls are. So a third party, your cell carrier, knows who you called. And so what the courts have looked at is, well, if you're allowing, waiving, guaranteeing that a cell phone company can know who you are calling, then that's really no longer a private matter, because a third-party company knows this. And that's the same thing with where you're standing. The cell phone company has the ability to know where you're standing and where you made a phone call from, not only today, but yesterday, a week ago, a month ago, a year ago. And if you're voluntarily giving that information up to a cell phone company, then why can't the police use that for their purposes? So these are the issues that are being confronted at all times. Is your address book private? You know, if a police officer arrests you and takes your phone, can he immediately go in and look in your address book? What if you text message a friend and you admit you committed a crime, and the police officer doesn't seize your phone, but seizes your friend's phone? Do you have some kind of interest in preventing that? Does it matter that texts are only saved for a short period of time? Because of your generation, you know, text messaging has exploded. The cell companies do not have the capacity to save these things. They are, you know, so much storage is used to hold on to text messaging that they actually get rid of them pretty fast. Every cell carrier has a different time period, but most of them are somewhere within 3 to 5 days. So if the police know that you did something wrong and admitted it or committed a crime by text messaging, does the fact that the police know that that's going to disappear out of the storage unit that the cell company has, does that give them the right to seize your phone right there on the spot and start reading it before it gets deleted or disappears? All important questions. And finally, if a police officer can follow you on the street, if I could walk around and follow you outside of this building, follow you behind your car, follow you to your house, watch you pull into your driveway, if I can do that with my eyes, can I put a GPS signal on your car? Or more importantly, activate the GPS signal in your cell to know where you are? All of these items implicate the Fourth Amendment. in a way that no one could ever have envisioned 200 years ago. It's absolutely incredible. Is there a difference between your historical cell location, that is, where you were standing last week, versus where you are standing right now? What if you're the victim of a kidnapping and you're in the trunk of a car? At that point, you would all want the police officer to be able to figure out where you are based on cell technology, to be able to send a signal out to your cell phone to figure out where that car is. Does it matter if you're the victim or a defendant? These are all things that we're struggling with now with regard to this. I guess I should go back one. See that cell tower? See how it's a triangle, 3 sides? The technology is so powerful now that an engineer with a cell phone company can actually tell me, a prosecutor, what side of that tower you were standing on when you made a phone call. They can say, oh, he's on the north side, which matters greatly if a robbery or a murder was committed on the north side of that tower. And it matters even more if you lied to the police and said, I wasn't even in that area, and I can put your cell phone in that area standing right near the scene of the crime. It matters even more when you say, I don't know Jim Jones, who committed this robbery, and I get both of your cell records, and I can prove not only are you talking to you, but I can put on a map how you're moving towards each other when the crime is committed, and you move away from each other when it didn't. Incredible, powerful tool that we use all the time now. Every one of the things I've given you an example about evoke that document from 223 years ago, or more importantly, from 1791 when the Fourth Amendment was ratified. All of those issues evoke the Fourth Amendment. So how do judges apply century-old words to new technology? Well, typically the courts rule by what we call analogy. They say, okay, let's look at the way they dealt with it 200 years ago and see if it kind of applies now. So the question becomes, all right, if you mailed a letter from one person to another 100 years ago, would that letter be private? I think all of us would say, yeah, absolutely. But what makes the difference here is the fact that an independent third party you have voluntarily exposed that material to, and that's your cell carrier. So AT&T, when you're sending a message right now, if they wanted to, if they had enough time, or if they cared, they could know exactly what you sent to your friend. And because you are voluntarily exposing that to a third party, we believe, and it does, it allows a police officer or a prosecutor to know what that text message sent. So it's no longer private. By using some of this technology and by revealing it to a third party, you are losing that issue of privacy. And the way that they look at it is they look at it as to whether it's a reasonable expectation of privacy. If I write a letter, put it in an envelope, seal it shut, put it in a mail, and it has someone else's name on it that only they are going to have it delivered and opened, I have a great expectation of privacy in that. A tremendous expectation of privacy that no one else is going to read that unless I or the person I sent it to has turned it over. But if I send a text message to my friend that goes through, a cell carrier, and they could read it, they're billing me based on how much I do and how often I do it, and they know they have to direct it to a certain other person's cell phone, then what the courts have said is that your expectation of privacy is lower because you have voluntarily revealed that information to a third party. And that's what the courts have ruled. Now, I cannot, and my police officers cannot, just willy-nilly go over to AT&T and say, I want to see all of Scott Shellenberger's cell records. I do need a court order. But the level of court order that I need is somewhat less than a court order that I would need to say, listen to your phone calls. Because the cell phone carriers, while they know what your text message looks like, or they know who you are calling, or they know where you're standing when you make a phone call, they don't know what you're saying when you make a phone call. And because society knows that and has a great deal of respect for the privacy of the words that people speak, then it's harder for people to find out and get a wiretap on somebody who's talking on the phone. For me to be able to listen in to a phone conversation, it's a very, very hard thing to get. In fact, the law in Maryland is that only the elected state's attorney can ask a judge for a wiretap. And in fact, I'm the only one in this county who has to go in front of a judge, take an oath, and ask them to allow a wiretap. So the difference between your text message and your spoken word is a vast difference. And it has a lot to do with the fact that we have always tried to protect the spoken word as being a private matter. And when you apply that to new technology, it's because even the cell carriers don't know what you're saying. They know what your text message is, so the courts have said, yeah, you can get that because you're revealing that. But since the cell carrier doesn't know what you're saying, then you have a high expectation of privacy in your words, and therefore I need a special court order to try and listen to what you have to say. A lot of this depends not only on your expectation of privacy, but it's what you reveal to the public versus what you reveal in private. When I go outside today and walk through the parking lot, I am revealing my location to all who want to see it. I don't have a great expectation of privacy in my public view when I walk across the parking lot. You could follow me home. You could walk behind me the entire time. I have no privacy expectation in walking around in public. What I expose to the public, there's no expectation of privacy. But when I go behind a closed door, particularly the closed door of my house, that is when the Fourth Amendment kicks in. Because remember, that's why the Fourth Amendment was written, to protect you mainly in your house. And so you'll have a higher expectation of privacy when it comes to that. Why is there a distinction here? Well, what the courts have ruled is that if a police officer could follow you and watch you with his eye and follow you home, then he has a right to use technology like GPS to follow you in the same fashion, but electronically. He doesn't have to be right behind you. He can follow you electronically, either through your cell phone or perhaps through putting a GPS on your car. But what the courts have also ruled is, when you go in that house and close that door, the police don't have any right at that point to use technology like infrared to see if there's a warm body in a bedroom. They don't have a right to take the technology and put them somewhere they couldn't have been themselves. So while they have a right to see that you walked into your home, they could tell the world, Scott Shellenberger is in the house right now, they don't have the right to use any kind of technology to then figure out what room in the house I'm in. So their ability to use technology stops at the place that it traditionally did, and that is at the door. Now, if I walk by an open window, they have a right to say that because I'm exposing that to the public. Very interesting and complicated issues. Some companies know who you call, who you text, that's how they bill, and there's a less expectation of privacy, and that's why I get to know it. Since they don't know what you're saying, I can't know what you're saying unless I follow the Fourth Amendment. So let's talk about some of the other amendments, and then we'll take questions at the end. The First Amendment. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise or abridging the freedom of speech or the freedom of the press. Well, what does that mean today? Well, it means that we have open courtrooms. And like I said, you could walk into any courtroom except a juvenile courtroom and see what's going on there today. But what has technology done to that to cause problems? What does freedom of the press mean when you have blogs? You know, back in 1791, you had newspapers and people writing pamphlets. But what does freedom of the press mean when you have a blog? What does it mean when you have Facebook? What does it mean when you have Twitter? You know, in the recent trial during the Sheila Dixon case, there was great controversy over whether the press could Twitter out of the courtroom and let people know what's going on. And you all may say, well, look, if you can go into the courtroom and watch, why can't I sit at my computer and let somebody tell me what's going on there? Well, there's a lot of problems with that. The interesting thing about freedom of the press in the First Amendment is it says Congress shall make no law. And the question becomes, does the judge have the power to prevent people from communicating about what's going on in the courtroom? And many judges think they do. They think they have the power, and I think they do. They have the power to stop people in a courtroom from text messaging, Twittering, blogging, and telling people what's actually going on in the courtroom. The problem is you have to balance open courtrooms with the ability of the defendant to get a fair trial. And how do you do that? Let me give you an example. Say somebody confessed to a horrific murder, but for some reason the police didn't comply with the rules like Miranda. And a judge has ruled the confession cannot be used at trial. Well, what if people are sitting in the courtroom when they're ruling on that confession and they're all Twittering and blogging and texting and letting the whole world know, the entire jury panel know, that this person confessed, but the judge says you can't use it? How do you pick an impartial jury that? How does the defendant get a fair trial if that can happen? And the problem is, with so much social media out there, with so much on the internet, it's very, very difficult to pick a jury who doesn't know a lot about some of these very sensational cases. So that's one of the difficulties. The other thing is, what about security? You know, I have courtrooms now where we try people for gang-related violence. And their gang-banger friends come and they sit in the front row, and they not only try and intimidate the witness who's sitting there, but if they're permitted to text message from the courtroom and tell their friends who are also gangbangers outside the courthouse that, you know, somebody just snitched on our gang brother, and oh, by the way, he's wearing blue jeans and a red bandana, and he just finished testifying and is on his way out the door, that poses a huge security issue. Huge security issue for the witness, for witness intimidation. And if we can't put witnesses on the stand who feel like they won't be hurt or intimidated against, our whole criminal justice system comes falling down. So these are all really important issues that we have to address concerning all these things. How do you balance freedom of the press versus security versus trying to get the defendant in impartial trial with our First Amendment? An amendment that was written 200 and some years ago, when it would take days to get information out, to the number of people who now can get it in seconds, in absolute seconds. The Fifth Amendment, one of our most important amendments. This is the amendment that protects you from being beaten by the police and being forced to confess. No person shall be held to answer for a capital offense, but the more important three, nor shall be compelled in any criminal case to be a witness against himself. So you cannot be compelled to be a witness against yourself in any way. That was written and passed in 1791. But in 1791, we didn't have a lot of the complications and sophisticated young people that we have today. The practical effect is that you can't be forced to confess, but you can waive your right to that protection. And what the courts ruled in the 60s, and what you all have known ever since you've grown up, is that there's a thing called a Miranda waiver. And that is, it's a way of the police telling you about your Fifth Amendment right. You have a right not to confess, but letting you know you can waive that right if you want to. This is a thing the courts created to try and protect that Fifth Amendment right that had been around for a couple of hundred years. And you all know it very well. That's an actual Baltimore County Miranda card that every police officer carries around. And after they arrest you, before they talk to you, they read you those rights and try and get you to waive those rights. And that's what I meant earlier about every day our police officers and our prosecutors are living, breathing, and being guided by the Bill of Rights in our Constitution every day. So there's a Miranda card, and you can waive those rights. The question is, what does it mean if you're 15 years old and charged with murder? You all know Nicholas Browning. He killed his family out in Cockeysville, shot his mom, his dad, shot his two brothers. You know, can a juvenile waive this very important right and confess? And more importantly, in the Browning case, can he be questioned by police and waive that right when there's a lawyer standing out in the lobby demanding to see him? And the answer to that is yes. The lawyer doesn't have a right to get into the defendant. It's a defendant's personal right whether to waive or not waive his Fifth Amendment right. And in that particular case, Nicholas Browning not only waived the right, he eventually confessed. That confession was ruled admissible in court, and it was used to convict him. Same with another individual, Lewin Powell, 16 years old, confessed to killing his mother. Once again, you know, how do you deal with some of these new issues, and that is juveniles who are being treated as adults, although they're only juveniles, you know, do they have a right to waive these all-important rights? And the courts have said yes, they absolutely do. It's an ancient document, but it has universal protections. And the thing is that's interesting is we're constantly confronting all these new issues, all these new questions. This technology is absolutely swamping the appellate courts, and you're going to see nothing but more of it over the next several years as all these cases wind their way through the various appellate courts, and even the Supreme Court will ultimately decide how you apply that ancient document to all these new issues and the new technology. And with that, I'd be happy to take any questions.
If you want to for any questions, you can come down here and speak into the microphone if you don't feel your voice will carry.
And you can do the questions. Gee, I have a friend, he was driving in a car and police pulled him over. And so I'm used to answering those. Yes, sir.
How do you deal with the GPS? I found that kind of interesting. Or it sounds to me like anybody can come up to your car and talk about what you were saying.
Right now, the courts have ruled that if the police have what they would call reasonable suspicion that you're committing criminal activity, that they do have a right to put a GPS on your car and follow you in that fashion. And it's the same logic that I explained before. If they could get behind you in their car and follow you, then they have a right to use new technology to follow you. Now, the distinction would be if you were carrying a briefcase and they put the GPS in the briefcase. As long as you were driving around in your car or walking in public, again, no reasonable expectation of privacy because you're exposing yourself to others in public. As long as you were out in public, they could continue to follow you. Once you went into your house, then I believe that would be determined to be illegal because that's where the door ends. They couldn't follow you in there without a warrant. Well, there's some exceptions that are in the law, but they couldn't follow you in there without a warrant, and therefore they can't use the new technology to follow you in there. So I think that would be the distinction. Now, I can tell you, last session in Annapolis, a bill was introduced in the legislature to prevent police from doing that, from being able to put GPS on a car. The bill was defeated. I'll be happy to tell you that I was the main opponent to that because I felt that it was important that Maryland abide by the standard rules that operate all over the country concerning the Fourth Amendment and not niche out these little exceptions to, frankly, give criminals more rights. That was my response. But I wouldn't be surprised if it's introduced again in Annapolis. Yes, sir.
How is the philosophy that public exposure of information, text message, content being viewable but not all interact, email and encrypting content?
That's a good question. The question, to paraphrase, is how does the concept of text messaging and the fact you're revealing that to a third-party carrier interact with email and then also encrypting of email? It depends on, again, the emails that you're using. Email, once again, has to go through a carrier. And so a third party, Comcast or whoever, has the ability to see your email. And so I believe that given the right set of circumstances, you could get some type of court order to go look at your email. Now, the flip side is, not only is there not enough storage for people to keep all these text messages that are flying around, and they disappear very quickly, the same is true for email. I mean, you can't even imagine the storage capacity that you would need to save all these emails. So I would say that emails don't last, forever. Now, that having been said, if I had probable cause to believe you had committed a crime, and I had a belief that you had done something on your computer connected to that crime, then I would have a right to get a search warrant to go into your house and seize your computer and forensically examine that computer. And just so you all know, you might think you hit the delete button, and it might not be there, but it's somewhere in that computer. And in fact, we've solved crimes and used evidence against people in court based on email. Mary Kuntz, who killed her husband and took a shot at her daughter out in Manor Road, just got convicted and got life without parole. We had a number of emails that we got from there, but again, there we actually had probable cause to go seize her computer and actually pull things off of there. Just like, you know, nobody commits a crime without making a phone call anymore, it seems like everybody feels compelled to tell people what they did by way of email. And every search warrant that I see now, whether you're going into a drug dealer's house or somebody you suspect a murder, every police officer puts in that they want to seize any cell phones, any laptops, any computers, because these things are so prolific and people use them so much that we find a lot of good information on it. So, yes, ma'am.
How are you using expectation of privacy if somebody's talking on their cell phone or his cell phone?
Very good. And that's, again, the public versus the private. If they're standing right next to you and I can hear half of that conversation, then I could come into court and repeat what you had said. The point that I made was that I need a special court order to get in and listen to the whole conversation from both of you through the cell phone carrier or the telephone carrier. But you are correct. If you're on a bus and you're gabbing away and saying, you know, I just committed a crime, I would have every right to call anybody who heard that to the witness stand and let them say what you had said, because you had not exercised privacy. You had revealed it to the public. It's just that traditionally, the words we say on our phones are highly, highly protected because they've never been recorded. The third party has never known what you were saying, and that's why it's really hard for police and prosecutors to be able to listen into what you're saying. That's the distinction.
But is it getting easier because there's more of that out in the public with a cell phone? I mean, I can understand landline.
No, it's not getting easier because there's a difference between me sitting next to you on a bus and overhearing half your conversation and me going to your cell phone carrier, putting equipment on there, and listening to all your conversations. So there's a distinction between those two things, because you could have one conversation sitting at the bus stop, but the next one might be in your bedroom and nobody else is around. And I would have no way of being able to distinguish that if I'm listening to all your phone calls. So it's what the phone call thing is one of these things that Americans have always held with great and deep protection, just like the house. You can't come into my house unless you have probable cause and a warrant. You can't listen to my phone conversations, even if I'm out gabbing in the public all the time and you can hear half of it. So that's just always been a big distinction. Somebody else?
Yes, sir.
Yes, sorry.
How does the reasonable expectation work? Something that's happening now. It's a 17-year-old girl sends a provocative picture of herself to her 21-year-old boyfriend. There are cases now where people are serving time for what is the reasonable expectation of sending that to somebody and remaining private?
Well, the question is, what's the expectation of privacy issue if you have a 17-year-old girl sending a provocative picture of herself to a 21-year-old boyfriend? And this is what I tell all young people, her expectation is that that's going to be private and he's not going to reveal it. But when they break up 3 weeks later and it's on the internet, she has lost that. And that's why I tell people all the time, don't send anything to anybody like that, because once you hit send, you have lost control. And if you voluntarily give it to a 21-year-old, he can voluntarily put it anywhere he wants. On the internet, send it to his friends, or do whatever he wants. And so while she has an expectation of privacy, by revealing that to the third party or the second person, she loses that because she has revealed it. And he may promise her the world that he's never going to show anybody else. And all we can ever do is say he's a cad, and there's nothing we can do to control that.
No, but what's the responsibility
Well, not if she was 17. She would have to be under 16, and it would have to be more than a provocative picture. It would have to be substantially more than a provocative picture for him to be charged with child pornography. You know, I still think it's really poor judgment to do. I mean, I can tell you all right now, you know, when I hire new law clerks who are usually first-year law school, 26 years old, 25 years old, I have somebody check their Facebook page, MySpace, all these other things. And, you know, if they come back and show me pictures of these people acting like knuckleheads, I don't care what your grades are, how good you're doing. You're showing poor judgment by revealing this stuff to the world. And let me tell you, as an employer, I'm not the only person doing that. They're doing that in private industry now constantly. So, you know, I tell everybody I talk to, be careful what you post. Because once you put it up there, you know, you lose all control. And once you lose all control, you know, 5 years later, you might think it's been gone and everybody forgot about it. And suddenly you're going on a job interview and you can't figure out why you're not getting a job. So I think it's really important that folks think really hard about, you know, who they send what to, and more importantly, what they post on the internet. Okay? Well, I thank you all very much. I hope this caused you to think about some things, and appreciate your time.